Okay, we're ready.
Thank you. Will the special meeting of the Planning and Zoning Commission for Wednesday, February 17th, 2020, please come to order? This evening's meeting will be virtual planning and zoning meeting via the Zoom platform. I don't think I'm going to have to read our procedures because it's not a public hearing. So I will quickly jump. We're not making any decisions, so you don't have to worry about doing that. I don't believe we'll be taking any votes, but if we do, it'll be via a roll call vote. Present this evening are the following members of the Planning and Zoning Commission: Scott Edmond, Richard Wallace, Frank DeAndrea, Sean Cosgrove, Jamie Stein, and Bill Freeman. So welcome. Our town staff present are George Kroll, our town planner, Aaron Mannix, zoning enforcement officer, Lisa Piombino, planning and zoning administrative assistant. This meeting will be recorded via the Zoom platform and made available on the town website for viewing. Is there a legal notice for the meeting, Aaron?
No public hearings. Just to let you know, Alan is with us also.
Oh, well, welcome, Alan. There you are. Welcome, Alan. Alan Brown, ladies and gentlemen.
You're muted, Al.
All right. With that being said, and trying to be as efficient as we can with time, you guys all know Glenn Chandler. So I'll let him start the party and we can get the ball rolling.
Aaron or George, anything you want to say before I roll in?
No, we've kind of given that synopsis already that, this is our first draft. Everybody got a copy of it last week, and now we'll try to keep on point as much as possible to move things along.
I'll do that. Greetings, everybody. The last time I think I was with the commission was probably a year ago, maybe even more, before COVID, and so much has happened during that time period, which has changed the way that we all do business. But it's also provided an opportunity for George and Aaron and I to actually go through the regulations, both the subdivision regulations and the zoning regulations, to organize them in what we feel is a user-friendly way, clean up the language, bring it into compliance with state law, court decisions, and other things, and really try to set the framework for what we hope will be an efficient process going forward. So tonight, I know, is your first opportunity to see the regulations. These regulations are not close to being ready for adoption yet, for a couple of reasons. First of which, we're going to need to coordinate these with the zoning regulations, which we've been working on, and they're close to being ready to come to the commission, but they're not ready yet. You may be familiar with your current subdivision regulations referencing the street and sidewalks ordinance, and we've been working with Janice to update that ordinance and its procedures, and possibly actually split it up into a couple of different ordinances. And so we're going to need a final answer as to which way the Board of Selectmen is going to go on that, because we need to refer to this other document. So that's why we're not ready for adoption in the extremely near future, but those are all things that we're working on. I think the first way to get started is, if you have an opportunity to take a look at the table of contents. We tried to organize this in a way that kind of mirrors the subdivision process going forward. So it outlines the regulatory framework, which is just a couple of pages at the beginning, which outlines the statutory authority that the commission has to adopt regulations, how there's going to be applied and enforced. And so that's the regulatory basics up front. The next section is interpretation. These are the words and terms used in the regulations to set the framework for moving forward. Then there's two major areas of regulations themselves. The first of which, section 3, is parcel and lot standards. So this requires a lot to be a buildable lot. It requires open space to be set aside. It has provisions related to energy efficiency and sustainability. So that's the sort of lot or parcel. Now, parcel, the framework we tend to use is the parcel being subdivided is the parent parcel, and lots are the end result of the process, and those are the children, if you will, of the subdivision. And then section 4 is the section relating to infrastructure improvement standards. So if roads are to be built, these are going to be the standards that apply. how the drainage system needs to be configured to comply with the current standards for LID and other things. If utilities are going to be installed, where and how that needs to happen. And then requirements for sidewalks, street lighting, and other types of provisions. And then sections 5, 6, and 7 are organized in a way as to how an application would be processed. 5 says, okay, here's the initial stages of the process, which moves our way from receipt of the application through the referral and hearing process to the public hearing, and then action by the commission on the subdivision based on the standards in the preceding sections. 6 says, here's what happens after approval. The maps have to be prepared. The chairman has to sign the maps. The maps have to be filed on the land records. At some point in time, financial guarantees need to be provided. So that's what guides the process following approval. And then 7 is actually the construction process. These are standards related to, you really shouldn't be burying tree stumps and other types of biodegradable debris in the road area. You shouldn't be clearing and grading until your erosion and sediment controls in place. We have the right to inspect the improvements and stop work and correct if things are happening in a bad way. So I think for residents who may be interested in subdividing, they can understand what's required. For subdividers and professionals who have experience with this, the provisions that they're going to look for to remind themselves hopefully are easy to find. And then for the process as it unfolds, people could see it sort of in a logical, sequential manner. So
Glenn, just as part of your preamble, can you, I'm curious about, I know you've done work for many other communities who've gone through this process of reviewing and revising regulations. Have you seen similar scenarios as we have in Guilford, where the regulations have obviously needed to be revised, but is this kind of a model? Do you think have you used a model that you successfully introduced to other towns? And is Guilford different in any ways from other towns in how you've crafted this suggested revision?
Good question, Sean. I think the organization of the regulations is a framework which has worked well for other communities. I think the approach here is for the commission to be able to intuitively find what it's looking for in the regulations. If you have a concern about an application, you'd say, well, what do the regulations say about that? I think from this framework, you're able to find what you're looking for quickly and intuitively, and I think that's important. So on that point, that is to, as we discussed, many months ago, pre-COVID, that is to make it more, I'll say, just interested party friendly. So all of the stakeholders can interpret the regulations in a clear way. Is that right? I think a couple of things there. First of all, they can find the information they're looking for. So if they have a concern about something, they can probably quickly figure out where it is in the regulation. Mm-hmm. And then I think as a second part, we've also tried to make the text reader friendly so that ambiguity is mm-hmm. gone, so that there's really not a lot of interpretation for these types of things. I think I've had the opportunity to work as George and Aaron have as a town planner of advising a border commission. I've also worked on the development side. I've been a consultant. The worst fear that most people have in a regulatory process is what I refer to as regulatory gotcha, which is you thought you read the regulations, found what you needed to know, and you invested time and money in implementing that, only to find out when you submit it to staff that there was something buried in another place that you didn't know about. And it's frustrating. So I think our goal here as part of this process was try to get like provisions together with each other and make it clear in terms of the language so that people could find what they need, understand what they need, and then move ahead.
But is the goal here to make it in a sense, user-friendly first and foremost, or is it to either, slightly or fundamentally change the regulations?
No, I think the organization is something that has worked, but I think we took quite a lot of pains with George and Aaron to retain the DNA of Guilford's regulations from the past. So we've used sidebars on these pages to call out things to the commission's attention. So you'll see things in the sidebar that say,
Yeah,
tell
right.
PZC. So this is, if we change something, we're pretty consistent about calling that out so that nothing gets by the commission without you being aware of it. I think if the commission was to try to sit down and look at your current regs and compare it with these regs, that's a tremendous amount of work. So I think you have to put a little bit of faith and trust in us. And we have tried to identify places where changes were made for reasons that we're prepared to discuss with the commission. But we haven't just, tossed your standards out the window and brought in standards from another place because it was easy. We've actually spent quite a bit of time working through the regs, line by line, section by section, to make sure that based on circumstances and situations that have arisen in Guilford in the past, we've carried the current regulations forward or made conscious changes. And these are things we want to recommend for discussion with you.
Okay. My final question and comment, and you can bring this up later in our discussion as you work through this, this document, is, there has been a lot of public comment, in opinion pages, in articles in the Courier and the Hartford Courant about affordable housing. I'm just curious as to whether, you are incorporating some of the thought around those issues into how we go about both the subdivision regulations and the overall zoning code overhaul.
Yes. So I think, again, we've had an opportunity to work on both sets of regulations. And I think when you get a chance to see the zoning regulations, we put quite a bit of thought into how we could reorganize some of the provisions that Guilford has today and address some of these issues, which are front and center. And in this legislative session, there's bills moving ahead, which may, again, sort of fundamentally change the activities that, or situations that Guilford will find themselves in. But that's a great opportunity to bring up sort of the difference between zoning regulations and subdivision regulations. The zoning regulations are the big sibling here. They identify the standards for the use of property, the dimensional standards, and the other things that go on. So those are the regulations that do the heavy lifting for Guilford in so many different ways. The zoning districts, what you can do, those types of things. Subdivision regulations, I characterize with many communities, is essentially consumer protection regulations. The subdivision process, the basic purpose is that lots are being created, buyers would be interested in purchasing these, but it's a bit of a risk. You know, the story about buying land in the Florida Everglades or whatever, that how do you know it's buildable? And so the process, the subdivision regulations are designed to provide for an approval process so that people know a lot is buildable, that you can get water and sewer service to it. And the commission has looked at topography and access and all of those things, and the lots are buildable. Open space has been set aside to integrate it into the community as a whole. A financial guarantee is being provided for the construction of a road. So even if you buy the last lot in the subdivision furthest away from the road, and it might be a year before the road gets to you, you would have comfort purchasing that lot because the town has a financial guarantee or some other limitation on that subdivision, which means that that road will get there. We have state requirements and financial guarantees for that purpose. So these regulations don't necessarily dictate the use of a piece of land. They do dictate the parameters which support that use in terms of infrastructure, roads, drainage, water, sewer, or sewage in Guilford for that type of thing. So that's a long answer to your question. The short answer is yes, the zoning regulations, we've put some thought into that, and we're looking forward to talking about that with the commission.
Thank you.
I think just one thing to add, I think as you mentioned that this is formulating the regulations so that during a meeting we can go and see, well, what does the regulation say about a certain topic that we're talking about? I did want to kind of point out that we've retained a lot of the language in here about giving the commission the opportunity to, for lack of a better word, interpret as well. So there's a lot of parts which gives us the flexibility depending on certain scenarios that we can collectively as a group come to a decision. So it's not like we're necessarily changing what the abilities of the commission or responsibilities of the commission were before. It seems like from what I read, at least, it's retaining pretty much the same as what we had before.
Yeah, no, we're not changing the commission's statutory or other authority. I think, again, the issue here is to try to organize it in a way that makes the process run smoothly. And we've spent quite a bit of time, for example, looking at the process for financial guarantees. We used to call them bonds in the old days, right? Bonding of roads, et cetera. They're now called financial guarantees. The process is a little bit different. Do we have the best procedures in place in Guilford to manage this so we don't find ourselves in a situation in the future where we actually have a challenge? I think it's a refresh of the regulations you have and hopefully an improvement overall. I think what I'd like to do, if there's any questions on the organization or the overall structure of the regulations, we can sort of approach those now if you'd like. And then I think the best next step would be to kind of work through the regulations, either section by section or page by page. And if you've circled something in the text or in the sidebar and say, you know, Glenn and George and Aaron can explain this one to us a little bit better in terms of what's going on here. The time will come that the regulations will be before you for potential adoption. And if there's any tweaks, changes, or questions you have, this would be a great time to start to address.
So what I would humbly suggest is that maybe Glenn, George, and Aaron, you know, maybe there are more significant aspects of the suggested changes, and we start kind of in a sense with priorities, and then just move down in terms of importance.
Yep.
If that's possible, Glenn.
I mean, I think it is. I think we spent quite a bit of time working on refining. George and Aaron, I'm actually kind of flipping through pages, looking for things which are significant in some way, shape, or form. A note, even in a sidebar or whatever, that might call out to the commission. I really don't have anything major on section 1 or 2. It's not really until we get into section 3 that just a couple of things to start bringing to the commission's attention. Did you guys have anything before that?
Well, Glenn, just to follow up a little bit, I think the sidebar notes where we've highlighted for the commission's attention, those are the priority questions that we think we want to make sure you at least see, acknowledge, and if necessary, we can explain them more. I think another important point in terms of the preamble is that what towns are enabled to do vis-a-vis regulating the subdivision of land is extremely limited by what state statute says you can do. So that's why you'll see that this subdivision process is described here is basically the same as the subdivision process in every other town in Connecticut. So there's not a lot of flexibility, especially compared to the zoning regulations, in terms of the way you address, especially the process questions. And that's mostly what the subdivision regulations are, is process. But I think the best way to proceed, Glenn, is section by section, going and highlighting the points that we thought were most important to call to the commission's attention.
George and Glenn, you referenced, and we're all aware that the state legislature in both houses is probably looking at, you know, land use, and I go back to that affordable housing issue. I'm just wondering what we've built into this is anticipatory for what may be coming from the state, so that we're kind of ahead of the game.
You'll see that I'm sorry. You'll see that in the zoning code, not in the subdivision code.
Okay.
There's
Okay.
really not much you can do in the subdivision code that specifically addresses the affordable housing issue.
Okay.
But you'll
Thanks,
see
Joe.
we have a lot of discussion, and there's a lot of opportunity for you to make some decisions in the zoning code with regard to how aggressive we want to be in terms of promoting or encouraging or allowing various forms of affordable housing. So that's when we get to the zoning code, that's the time to really focus on that.
Thank you.
Glenn, you're just warming us up, right? This is what,
Yeah.
Yeah.
this is the warm up.
Right.
That's a good analogy, Phil. I think the zoning regulations, there's a lot of pages and a lot of provisions in there. And when you get them organized, which is really the first thing we did, other issues became apparent. And as George pointed out, the issue about housing and affordable housing, our communities are changing in ways we didn't anticipate. So we've cleaned up the open space conservation subdivision concept. We've cleaned up the PRD. And then we actually looked at where there might be ways that we could fill in some gaps to provide housing options and flexibility in ways that fit into Guilford. So yes, there's going to be a lot more to talk about, I think, when we get to the zoning regs.
Well, and the other part of this is that this is to allow us to easily and efficiently add to it if we need to, or change things if we need to.
Yes, I think we try to think of a structure, Scott, that would be amendment friendly, that the regulations, I think there are situations in your current code where the numbers are consecutive and it's really hard to fit things in. The designation of articles doesn't always tie to the sections. And this is very much a hierarchical structure. So you say, okay, well, we need to add a new infrastructure standard for blank. Boom, that tells you where it needs to go, and there's numbering available for you to be able to put that stuff in. So we're hoping to make it future friendly as well. I think following George's advice here, section 1 is really just about the framework for the regulations, the conformity with the standards, et cetera, is required. The overall administration of the regulations. I think the biggest section here is page 4. Page 4 is a provision which allows the board to modify the standards in the regulations. Now, a zoning commission has the zoning board of appeals, and they address issues of hardship related to zoning standards. And there's no functional equivalent in the statutes for a planning board of appeals. And so the legislature gave this to the commission. If there is a situation where the standards, when applied to a particular piece of property, produce some kind of hardship or physical difficulty, which might result in a, quote, taking, unquote, of property, you have the ability to modify standards to address that. And the requirement in here is that you have to have a supermajority vote. And so there's 2 types of waivers the commission could grant, one of which is an application requirement. Somebody is simply lotting off on an existing road. The standards sort of require that you submit a plan and profile drawing of the road you're building. Well, you're not building a road, so that standard doesn't have to apply. You can modify or waive that. But if somebody says, well, I don't want to do that much open space set aside, or I don't want to, I'd like to narrow the road width, that requires a waiver on the part of the board, and that's what's laid out here. So that's why it sort of appears at the beginning in this fashion here, and it does require a 3/4 vote because it is a sort of a quasi judicial standard based on hardship or something else. So it's a provision which may come into play in the future, and here it is for you.
So Glenn, it says no waiver shall be granted that would have a significant adverse effect on adjacent property or on public health and safety. And that's subjective. I mean, that is subject to a planning and zoning vote.
Yep.
Okay.
Do we define supermajority within our regulation?
I'm sorry. Yes, it does, Phil, right there on the top of the page on item number 1, 3rd line down,
Sorry,
3/4 vote.
thank you.
So that's what this is. I guess to sort of Sean's point here, this is not like, oh, well, I like the applicant, or, I'm concerned about this or whatever. The issue ends up being a 3/4 vote. It could be a situation depending on the number of members in attendance that night. 1 vote is
So
enough.
Can I play a little bit of devil's advocate on this?
Of course.
If we have a full seated commission, we have 7 members. and a supermajority would require 5.25.
Okay,
I'm glad you brought that up, Phil. I was thinking about the numbers and what represents 3/4 and whether this board should be reduced in size or increased in size to meet that standard.
I'd like to be able to help you guys, but the standard is in the statute.
Okay, so,
But Glenn, the statute
So we need
is
six.
a state
or
statute.
Depends on.
okay,
The
So
issues they gave the commission amazing cosmic power on this particular issue. But they gave you itty bitty navigating space. So the issue is you need to have 6 affirmative votes. So if you only have 5 people there that night, you cannot grant the waiver.
It doesn't pass. That's right.
Doesn't it?
well, is it 3/4 vote of the seated commissioners that evening if you have a quorum?
No,
Says
it's
all
all
members.
members.
Of the commission.
So the legislature is not trying to make this easy or convenient. You can see that. They
What a
just-
surprise.
Well, the story gets better later, but I think the idea here again is a waiver is something that could be abused, and the legislature said, all right, we're going to grant you this power, but it's only under these conditions. And so it's a very narrow situation. So
Here's a question. And I don't want to put you on the spot, Phil, but is it in the town charter what the number of commissioners on?
Yes.
It is in the state. Okay, the charter. Okay.
I think it defines it as 7 with 3 alternates. 2 for the party that's in power with first selectman and 1 for the other party. And-
Yeah.
and
So
all-
let's try to revise the town charter.
Does the
No,
charter
I don't
specifically
think- I
mention
don't think-
parties though? I don't
we've
think-
already bit off a lot here with the road ordinance and the other stuff. But let me do this. I will go back to the state statute. It's 826. It's referenced here. And I will just confirm the 3/4 vote of all members, et cetera, just to make sure that I'm giving you good guidance here. So
Okay, thank you.
I do have a question. Does that include alternates in the majority or just the seated members that are full members?
it's,
Says
well,
all
if
members in
a
here.
regular member was not in attendance and an alternate is sitting,
Seated.
yep, then you need 3/4 of 7 members is my understanding of the way the statute reads.
Okay, thanks.
If we need to ask Chuck this, we can. Chuck didn't give us any feedback on this because he thinks we got it right. So we'll check it and come back to the commission.
You know, so it could be rounding up.
Well, it says, the statute says 3/4 vote. So you can't round down to 5 and say close enough,
Yeah.
right? You need at least the 3/4 vote. So.
Yeah.
I'll interpret things as best I can for the commission, but I don't think this is one I can help you with.
All right,
So that's the overview of section 1, unless George, Aaron, or any of the commission members had anything to add. Section 2
No.
is the interpretation section of the regulation. It basically lays out the definitions. We've added some language on the bottom of page 5, which says, for whatever reason, if we haven't defined something in these regulations, you can look at any of these other sources in making the interpretation. And think of the commission a little bit of wiggle room. We think we've got the key definitions in here from your current regulations, et cetera, but we've also given you some references should you need to go elsewhere. I think
Can you enlighten me about Black's Law?
Black's Law Dictionary is just a regular, it's a recognized source of legal definitions.
Okay.
I think that my sense would be, my advice to you would be to kind of start at the top and work your way down. So start with the zoning regulations, because now you have internal consistency between those two. If you need to go to the state building code, which probably not in the subdivision regs quite so much, although we did have some issues that we were working through in terms of holding up certificates of zoning compliance based on subdivision standards that we had to kind of work out. The Connecticut general statutes often would provide a definition for you. The Illustrated Book of Development Definitions is just a great source of stuff. So should something really kind of funky come up, they might have a technical definition for you. And then last but not least, the general dictionary. I think from all of those, you'll frame the issue that you need to make a decision on, and then you can make an interpretation on that basis.
All right.
One of the things we did in the regulations and the definitions sections is we tried to highlight or group like terms together. So these are the blue boxes you'll sometimes see on the pages. So for example, you understand lot better when you understand that parcel is the parent, and then you understand parcel better when you understand lot is the child. Flood-related terms, street-related terms. I think we're going to need to coordinate these again with the zoning regulation, what Janice is currently working on with we're calling it the road ordinance, but in fact make it a different name. The current ordinance is called street and sidewalks, and we think we're going to split it up and maybe call it roads, but we're waiting for Janice to complete her work. We have, I'm up to page 12 and 13. Our definition of subdivision, re-subdivision, water course, inland or tidal wetland is really dependent on the state. I think your current regulations for the definition of water course referred to a local definition, which really you can't really change the statutory definition. So in all cases, we've said in those situations, the term is as defined in the general statutes, and then the blue boxes summarize what the text says at the time of this crafting of the regulation. So you can accept this or go look at the statute yourself. And I think that kind of covered it for the interpretation section. George, Aaron, anything or any questions from the commission on that?
No.
So in section 3,
Nope.
which is parcel and lot standards, the first part here is protection of important resources. And this is where we wanted to lay out the responsibility or obligation of a subdivider to look at natural terrain, historic and archaeological resources, stone walls. We've carried language forward from your current regulations, but the way this is crafted, I wouldn't want the commission to think that you have tremendous power to preserve stone walls. Subdivision regulations regulate the act of subdividing. So in that narrow window from when they get approval to when the subdivision the map is filed and lots are being sold, that's your window. And unless as part of the approval process, you can get an easement or something on the stone wall, that wall could be sold, dismantled, relocated, et cetera. It rolls with property. So the yellow note here in the sidebar is that an ordinance might be a better long-term option here for the town. So we've tried to carry forward what you had, but I wouldn't want you to get too crazy thinking that this preserves all the stone walls, because unless the property is being subdivided, it really doesn't. These regulations apply during the process of subdivision, and that's about it. So zoning could be a place for us to try to address this, but again, it doesn't necessarily stop them from being sold. On page 16, we've had farms and agriculture, because we do have the right to farm ordinance number 164 in Guilford, which addresses that particular issue. And then we've also recognized that we can't have significant trees. So we've added in a provision that requires that significant trees be identified. And if they're within 50 feet of an existing or proposed street, try to preserve those trees to the extent practical and possible.
So I have a question on significant. What is the definition that we're going to be following with regards to?
I glossed over that back in the definition section, but it says a healthy tree of a species indigenous to Connecticut and having a diameter of 18 inches or greater, measured 4 feet above grade at the base of the tree.
And
That's a pretty substantial tree.
I was muted. Unfortunately, I didn't know, couldn't get it unmuted in time on the stone wall thing. Are we then to decide now at this point if we want to strike that since it's relatively toothless?
It's your call on the part of the commission. I think that you may hang on to it because it's been part of your regulations for a while, but I think it actually is a little bit of a paper tiger, Bill, because the tools for enforcement on subdivision just aren't that great. You have better tools for enforcement under zoning, and even those aren't that effective. So if
how does one even determine if it's a colonial era wall?
Most of them are. But I mean, apparently, I mean, you would look at them and there's a couple of pictures in here I found. I Googled, Guilford stone walls and came up with a couple. So I think this could be a situation where you might communicate with the Board of Selectmen and say, we've been reviewing our regulations and we urge the selectmen to consider the possible desirability of a stone wall ordinance. And
Can I
see what
go
happens.
out of-
That, Glenn, that provision was the Guilford Preservation Alliance made a really big deal when they proposed that we include this in the subdivision regulations, 10, 12, 15 years ago, whenever it was. And the idea was that they would at least be identified, on the subdivision plan or the site development plan, so that there'd be some highlighting of the fact that the stone walls are there. So if we were to propose to eliminate it, then we would pick a fight with the Preservation Alliance, basically.
George, would the Preservation Alliance have pre-identified significant stone walls of historic importance, or how would that work?
I don't think that they've ever done that.
This isn't like Gettysburg where they're fighting behind walls or anything.
And plus, when you get a survey done of a piece of property, any surveyor is going to locate all stone walls, regardless of whether there's a provision in there to justify their age. They'll just put them in as existing stone walls. So I just personally think it's kind of silly if there's no way to enforce something to have it in there. It just causes confusion.
I totally agree. I love the stone walls, out in the wilderness, but that just seems adding something we don't need to really worry about too much.
I think there's a way forward here in the sense that, as George indicated, I wouldn't recommend to the commission we pick a fight over this one. I think that the tools aren't great, but item 3B on page 15 says to us that the commission may require the creation of conservation easements or similar instruments.
And
So
that's been done before, Glenn. We've had conservation easements along the road fronts to maintain the character of the neighborhood, to preserve that street front. So
That's a
This
good point,
gives you the
because one
ability
of the areas where we do have some authority is with regard to requirements for open space. And it could very well, as you just suggested, that perhaps satisfying the open space requirement would be to create an easement for an area of stone walls. So having them highlighted somewhere is not a terrible idea.
no, and I think George,
But the point Aaron's bringing up is that, Aaron, are you saying this has come up before?
the commission has approved conservation easements along, along street fronts, whether it's to preserve trees in that area or, to reduce clearing there, or in another example, it could be stone walls in that street front. So it's not necessarily something that could be out in the woods. It could be along the road frontage of an existing road. So
Can I just float one idea? Does anyone get the sense that a tree with an 18-inch, is it diameter?
they call it caliper fill, which is a diameter.
Okay, so it's 18 inches from side to side.
Correct.
That's not that big a tree. I mean, it's not insubstantial, but there are a lot of trees that fall under that classification.
Well, this requires that they be identified, so.
But that they be indigenous, I'm not sure they use the term native, but
It just seems to me like you could have a Norway maple growing up in your backyard pretty quick. And all of a sudden, once it gets over 18 inches, then
we don't want those trees, though.
No, trust me, I don't want them either.
Norways can go.
Yeah, they're bad trees.
But yeah, depending on the species, it could be a lot older.
Just food for thought. I don't know.
Would a tree of significance then hold somebody up from actually dividing a piece of property into the allowable lots for that?
No,
Well, I think the way this regulation is set up, if it's within 50 feet of the existing or proposed street, you have to identify it on your survey. So the surveyor would pick those up. Unless authorized by the commission, any such significant tree shall be considered for preservation unless it's, you tell us, you exit out, and say this tree is history. I'm taking this one down as part of my plan. So it's just, again, just disclosing to the commission that there is a big tree and I'm going to take it down. C on page 16 says, unless otherwise authorized by the commission, the tree shall be protected by a 4-foot high, like snow fence around it, protect the drip line in the roots while construction is going on, so that you don't basically kill it by trampling on it. Damage to be repaired by Connecticut licensed arborist. And if you designate it for preservation but then remove it, then we may require you to replace it with the same cumulative caliper of trees. So if you took down an 18-inch tree, then you might have to put back 6 3-inch trees.
No,
Too much?
I'm finding this very.
This is
Not
not
just
something,
but it
Sean, this
just-
isn't something new that we're proposing. This is in the existing regulations.
I know, but I drive down Long
Clear
Hill
about-
Road, I see the development. I'm not sure it's a Vigliotti, but on Long Hill Road, right near Alpha, on the
Yeah, that's figure out.
road, and they've been just taking down trees wholesale. There had to be 18-inch
Yeah.
trees. Now, whether they met the strictest definition that this regulation
This is new language, isn't it?
Yeah, I think my recollection is that this came up through our conversation with Kevin. And so the
So,
issue was,
I'm just saying,
It's new? Okay.
this is just really, it's I'm
Let's
not
flag-
sure everybody agree. It just seems overly strict.
Let's flag this one for additional discussion.
Yeah.
I-
got it.
Thank you.
Thank you.
Sure.
Page 17, just as a sort of a hint here, looking forward, there have been concerns expressed in Guilford over the perm interior lot and what that has resulted in the definition. We are moving towards resolution of that issue or addressing that issue through the definition or designation of lots as either front lots because they front on a street or rear lots because they're to the rear on the street. So a rear lot is basically what we often think about on an interior lot. But in the current zoning regs, the definition of interior lot includes non-conforming front lots. So it creates all sorts of challenges. So we've tried to simplify that. We've carried that concept over here into this regulation, and that's why you'll see the phraseology in here about rear lots. Some communities actually have a special zoning approval process for rear lots. Other communities simply allow them, or they actually put a cap or limit on them and say no more than X% of the lots in a subdivision can be rear lots. And so Guilford's got some different areas and neighborhoods. Our lot sizes go from R1 and small to R8 and big. So we could look at this standard 2, flag this one for flag, right? Flag lot. We could flag this one for further discussion as we go ahead, but it is an issue that has some public safety implications. We've gotten a little bit of pushback from fire in terms of trying to get the houses on long driveways and the driveway splits and which way do you go and sort of all of the other stuff. So they're not enamored with this concept from their area of responsibility. Yet in Guilford, it's a large part of the character of many parts of the community. So this is one that we may get to the public hearing and have testimony on sort of both sides in terms of the situation. So just wanted you to be aware of that.
In 4B, does it say that you're going to be required to get approval from the commission to have any rear lots?
That's current in our regulations, that it does require that the commission may authorize.
What we're trying to do is try to avoid a situation that to create I guess a presumption, if you will, that you don't necessarily get approval for a rear lot if the commission doesn't specifically approve it and authorize it.
You don't get it by right.
What are the
It's hard.
criteria that we would follow as a commission that would allow us to see it as a viable option?
I think depending on the length of the driveway, the degree of access, we have limitations on the length of cul-de-sac streets, the number of lots can be served. And if people just keep adding on sort of rear lots, interior lots on driveway, on driveway, on driveway, then, the ability to get public access. So maybe in fact, it's a waiver, or you sign something provided for the record that, the property owner on the deed acknowledges the fact that fire department may not be able to get there. We'll do our best, but there's no guarantee. So these are challenges for these reasons. And I think, again, environmentally, they can help preserve important resources. Driveway is gentler than a public street. But then when there's a fire or an ambulance needs to get there and we've had inches of snowfall, it's a different issue. So this is one, again, where I'm just going to put a flag note here, continue to discuss this.
I think that's a good idea. I agree with
But
that.
is there an area somewhere that would direct us as to the maximum length a driveway could be, the maximum number of houses it could be on a shared driveway?
Yes,
Where are those
in here.
further down?
In the standards.
Section number 5 says that at least it restricts the depth of the lot. Could not exceed 2.5 times the average width. Oh, that's width. Just kidding.
That's an RA.
Yeah. Right now, the maximum length of a driveway is 750 feet, and 3 lots can be accessed by one driveway.
And what
And that
frontage does a,
changed, so that wasn't always. We do have lots that are, private driveways that are.
There's some ridiculous ones. When I was
You can get lost.
looking for houses here in Guilford, there was at least one that had like 12 houses on it, and it was a half mile long. It's
Yeah.
crazy.
And to note, the creation of rear lots in an R1 and R2 zone is by special permit now.
So I used to be a town planner some years ago in a community that basically said any rear lot is a special permit. So as part of the special permit, you would submit your request and we would run it by fire, police, emergency medical, all the other stuff, public works, get their comments and come to a decision from a sort of factual perspective, whether or not it made sense. And if the issue, is, listen, to get one more lot, I'd have to build 1,200 feet of the road and the town would have to maintain it. You might say, well, hang on, it's like, maybe we don't want to do that. So we might allow, but it becomes a conscious decision and the commission has discretion on a special permit, whereas you don't have quite as much discretion under subdivision approval.
Right.
Courts is considered to be a kind of an administrative approval.
Well, I would not want to put anything in place that would be considered an infringement upon property rights, but those are reasonable considerations.
So I'll flag this one.
Thank
And
you.
we'll come. On the next page, on page 18, what you see in front of you in section 3.3, lot buildability. We're actually thinking about splitting this up into 2 sections because there's some important provisions in here which are buried. Under 3.3, number 1, it says that it has to conform to the health code in terms of sewage disposal and water supply. Right? It is buried under lot buildability. So we're going to call that one out and say, this is actually a section related to water supply and sewage disposal. So it's clear, easy to find and readily apparent. And then the other sections in here will go into a lot buildability section. We just think that would make this section more user friendly.
And I had a question on number 5. Number 5, for those who don't have it in front of you, lots shall be graded to prevent ponding of water on the lot after construction of streets, drainage, and buildings completed. My question was, should this be a little bit more specific? Rather than just saying it should be graded, should it be graded per the subdivision like drawings, or you know what I mean?
Well, the only thing is with a site development plan, you have to submit a site development plan as part of the, to show that you can accommodate a single family house and the septic system and water. However, you don't necessarily have to build that design. So,
Right. I mean, we've had concerns of neighbors sometimes for some of these where they're concerned that whatever grading is going to happen is going to send water their way. And I didn't know if there was.
right, I think that should be in the zoning code.
And I think it's also addressed as we get later on into the stormwater management section of the regulations. But
So this is more just specific to the lot that we don't want ponding to happen.
yeah, I think that ponding can have deleterious effects on the lots. And if you were purchasing a lot and then you go out there to view your new purchase and you suddenly realize that it's graded in a way or has been collecting drainage water, no. We have authorized it for buildability. We'd like to make sure it's drained or graded to drain. And then I think we're okay going forward.
So I have a question, Glenn. I think this is one of those areas where the subdivision regulations and the zoning regulations in terms of the affordability efforts that are going on right now. I know that one of the target areas for housing affordability is around minimum lot size. So are we touching on that here? I mean, I can't really, the only thing I see here is that you have to be able to show adequate sewage disposal, but we're not saying like 10,000
No.
feet. We're not saying,
So those standards, Jamie, would be in the zoning regulations themselves. And this simply, for example, the subdivision regulations say, it doesn't matter actually what zone you're in, if it's R1 or R8, whatever it is, you have to demonstrate that you can get a well and a septic on there or water and sewage in compliance with the health code. And that's what we care about. So there's some court cases that basically say you can't use the subdivision regulations to establish minimum lot size requirements. So that's why it's in zoning. And these regs say you have to comply with the zoning regs. So we got that. I think we got that covered.
thank
I
you,
mean, the fact that Guilford, never put in public sewer is
is going to be real.
that's the reality of where we are.
Section 3.4 is the open space section of the regulations. We're coordinating this with the conservation subdivision provision, which will be in the zoning regulations. And that basically allows a lot more flexibility in the design and configuration of the subdivision. The lot sizes can get smaller provided you provide more open space or preserve more open space, or as you will see when we get there, you will provide for affordable units. You can do some other stuff. So we've addressed that. I think based on George's comment earlier, I'm going to suggest that in line 1B, this is where we can use open space to protect and conserve historic and other community resources, including agricultural lands. And I think we could add stone walls there.
Good idea.
I think the provisions in here are for on page 20, number 5, the dedication of land. You can either designate land on your parcel if you own land somewhere else in town, or you can get land somewhere else in town and give it to us for open space. Maybe we'd like that better. Might be a more significant parcel. We'd like to try to avoid measly little parcels of open space, but get some meaningful parcels of open space. So we've tried to provide flexibility in here to allow this discussion to happen. You have an obligation to provide for open space, and how you do it you can be flexible on, provided it's acceptable to the commission. At the bottom of page 21 is a provision. The statutes also allow for a fee in lieu of land. And so that provision exists here as well. Another issue which you should be aware of and we should discuss is on page 22.
Can I just interject briefly? So this has come up before the commission, and it says the commission may require. I just think that subjectivity of may or shall.
Where are you reading the may, Sean?
10A.
Fee in lieu of land.
B.
Okay, so let me just roll you back for a second. If you can go back to number 1 on page 19 at the top.
Yeah.
It says every subdivision shall make adequate provision for open space. Okay, so we've set the standard. You have to do something. You can either give us land on the parcel, land somewhere else in town, or there can be situations where we may accept a fee in lieu of. Now, there are some towns in Connecticut that provide for fee in lieu of, and the developers pay it happily because it frees up land that they get more lots on. All right. So as far as they're concerned, they're not going to do the open space. They'll give some cash and they get more lots, and it works out economically much better for them.
My only point, I just want to, maybe your point about 1A relative to 10A
Yeah.
makes sense, but I just,
So can I, while you're thinking about that,
if this cleans up what we've had to deal with before, that's
Well,
fine. Want to be
yeah.
sure.
We did have a language in our regulation that did not give the commission the authority to require the fee in lieu. It was at the
so
where you're at our current regs, we're at the mercy of the applicant on what they're deciding to do. And often we were getting these conservation easements or these, trying to do these
And
parcels.
the conservation easements were dependent upon someone else accepting, right?
In some cases, yes.
Yeah,
And
that doesn't work.
Yeah, some areas it makes sense that the commission has the authority to say, no, we don't want that. We would prefer the fee in lieu. And so I think when this was worded, it now gives the commission that.
Okay,
so
as long as that's the case, I'm fine with it. I just don't want to have an applicant before the commission say, you did this before, and now you're changing your mind, and I've got similar circumstances, and you're not treating me the same way.
So
Unfortunately, we've done it a lot of ways.
Never happened
happen.
before.
here's a quick question. Under 10C, and it said shall not be required to be more than 10% of the fair market value of the land. So
That has come up before too.
That's
so
the
then,
statute.
we can do it 1%, we can do it 4%. We can't go more than 10. It doesn't really kind of set
Yeah,
up.
I agree, Phil. I think that's open space for, either
Why'd you do it for him and not do it for me?
disagreement. Yeah.
We did have conversations with Chuck on this as far as a recommendation on a policy of how the commission does this based on appraisals of the property.
Phil, but then we hit that really expensive lot like a couple meetings ago.
So perhaps another option would have been for the applicant to have an appraisal done. And whatever that number was, if that was something that the commission.
Which is what he
decided
did
to
actually in that case.
But I guess my concern is it says will not be required to be more than 10%. It doesn't set a requirement number.
Yeah, I thought it was gonna be 10%.
I think the statute is using this language, and I think when we ran this by Chuck, the issue was to try to parrot the statutory language here. So I think this section, I actually kind of like the way it's worded. In 10A and B, it says you can require a fee in lieu of. If somebody's giving you a piece of land that is a pimple off in the woods and doesn't tie into anything, it's an obligation, it's a menace, it's not, no, we don't want that. So you can in fact require the fee. Say, we don't want the land, we want the fee. So good for you, you get that choice. And B says that if he offers the fee and you look at his property and say, no, that's an important connection between these two open space areas, you refuse the fee and require the land. So there you go. If you take the fee, the statute says you cannot require more than 10% of the pre-development value. It can be the commission's policy. You can instruct George and Aaron to say, if somebody asks, it's our policy to do 10% unless you can convince us otherwise. So I can't say that in the regulation, but I think you can.
It puts us into a sticky, so there was a parcel that came before us a couple of meetings ago that recently sold. It was part of a 4-acre, it was half of a 4-acre parcel that sold for, $2.1 million. It was just like tombstoned in the paper. So, that's the sale price. It's hard to argue that that's not what the vacant undeveloped land is worth. So you're talking about a fee of, not more than $210,000. And I think we required them to pay 12,005 or 15 grand.
12.5.
Yeah, and I think about someone who sells a lot for $50,000.
And pays 12.5.
Exactly. That does not.
That is not good.
Well,
It's not good.
I don't want to scratch the scab off of something the commission's been dealing with. But this is what the statute provides for. I think that you did all the right stuff in terms of you discussed options to a $210,000 payment, came to an accommodation that you got a majority vote on the part of the commission or consensus as to what to do and rolled on. So I think put it behind you and that's okay. And in the future.
But I don't want to over-regulate or over-specify, and limit the, the ability of the commission to make judgments about, what's reasonable.
Yep.
But the way this is worded right now, I just think it leaves.
I'm gonna put a flag on this.
Let's put a flag and say, can we find a way
Yeah.
to tighten it up so there's less onus upon us as a commission to, assign or determine what we think is the appropriate fee, whether it be, something.
Aaron, didn't the attorney indicate that it's supposed to be 10% and not less, or what was the final decision on this?
It's the statute, what the statute was.
And what was his interpretation?
I don't have his notes in front.
Probably
of me.
this
I
language.
think it's no more than 10%, I think. Historically, we've been required 10%.
So why did this person who was selling their land for several $1 million pay $12,000?
12.5, yeah.
And why did the guy who's selling his lot for $50,000 still pay $12,000? I don't understand that. It was the first time I ran across it, but I didn't understand it at the time.
Yeah.
Glenn, have you seen other towns deal with this in a more way, or is this just kind of one of those vague aspects of state regulations that towns deal with one by one by one by one?
I think they do. It's not common, if you will, that a parcel of land, I'm not sure how big it was, sells for $2.1 million as raw land. So I think that circumstances of that dictate. I had originally, when was working with George and Aaron on this, we'd crafted this section to say that you didn't actually have to pay money to get an appraisal on this. You could actually use the assessor's assessed value of the land, like they assess the market value, and this saves the money that somebody would have to pay for an appraiser, and that might actually get you a better outcome or result. And Chuck advised us to take that out because he said that statute doesn't actually allow for that. The statute says. So Chuck's right legally. Practically speaking, the bottom line is all you need to do is come to a resolution with the property owner what you think is right or fair. You can't charge more than 10%. So I'll make a note of it and we'll see if we can find a way maybe to get to some sort of framework on this that works.
There's things that we're going to have to take responsibility for. I mean, and like we each individually have to just decide what our point of view is, whether that person should have paid 200K or 12K. I guess there's some things that we're just as a commission are going to have to take responsibility for, I guess.
Maybe a thought of potentially putting it, and I don't know if we can do it legally, putting in a cap saying, okay, no more than $25,000, indexed over time. I don't want
that would just be a policy. But like
somebody might come in with a large parcel of land, knowing that they can get you to take no more than 25 grand, and they end up.
I retract my statement.
So what I was thinking, almost like income taxes work. Maybe something is graduated. I'm not sure, but I think we have to revisit this.
Yeah,
I agree. The ambiguity is going to be the key here.
But isn't it from an ethical standpoint the same for the $3 million piece of property as it is for the 50,000?
Bill, I agree.
But at
we'll
the same time,
continue to.
Why not?
at the
Why
same
not
time,
stick to the
it's
percentage?
right. But at the same time, it's just a decision that 7 of us have to decide on at the same time. So
But I think that sets up a situation where each commission, as it rotates through different people, everybody gets a different flavor.
Oh, we
That's
didn't-
right.
things change. I mean,
That's
We've changed it. You
that's
guys are all now
exactly right.
lifetime appointees.
I won't stand for it.
Good for you. Good for you.
I mean, I hear all the time that like the commission 10 years ago was very different than the commission is now, and that's going to continue to change and adjust over time. So the
I
regulation.
feel like the more
to
things you
allow for
have,
that.
And
the more
Scott,
things you have
as,
figured out, the better off the commission is over time.
and as the commission changes, the town will change. You know, it's,
The commission is supposed to be representative of the town as well. Yes. So I don't know. It's a hard balancing act, right? You want to allow for. Go ahead.
Let me just clarify one thing. The current language, it's not clear that the commission even has the ability to require a fee in lieu of the open space. The language is such that it suggests that the applicant has to actually agree that the fee in lieu of open space, the in lieu of part, is acceptable to them. I think that's what the lawyer was kind of alluding to in the case of the property down in Station
Yes.
Set.
I think you're right.
Under the proposed language, the commission can absolutely require a fee in lieu of if the commission decides that none of the other methods of open space are acceptable. And that fee in lieu of can be 10% of the value of the property. Now, it doesn't mean you have to require 10%. I think the case of the property that we looked at, that we've been alluding to, is highly unusual. And it being a small property, two lots or one lot, worth $2 million or $3 million. So I wouldn't hang our discussion on that particular situation.
It's just, the problem is that's the outlier. That's the one that when someone wants to drag one up and
Right.
say, here's what you did,
Right.
Phil.
But it's
Well, we
all,
should have charged them
but it's still all
$200,000.
proportional to the value of the lot.
All right.
it's,
So
all
let's,
about- it's all about the chairman.
right. Let's, yeah.
You guys don't start
Okay.
behaving, I'm gonna send you to your room, so.
All right,
Um,
I flagged this one for further consideration. Let's keep
Well, I
going.
apologize because I've got another one for you now. So if you go to the next page, page 22. The statutes provide two exceptions, if you will, when somebody doesn't necessarily have to provide for open space as part of the subdivision. The one situation is it's for affordable housing. And so you can modify that in order to encourage affordable housing. So there you go. And the other one is when the transfer is for no consideration to a parent, child, brother, sister, grandparent, grandchild, aunt, uncle, or first cousin. But there have been examples around the state. I've been called in on 2 of them where clearly it was kind of a sham, I guess is the best way to describe it. So I've added a look back provision here. And you should think about this. So if you look at 11A second bullet, the commission may require the filing of a lien or encumbrance which will expire at the end of a 5-year period. So if I tell you, well, I'm going to, I got all these cousins and I'm going to, give it to them for no money, and I do that, and then they sell the land, right? All they did was try to avoid the open space. And the issue is if they do that in 5 years, then the issue is you can get your fee in lieu of. So it's edgy. There's only about a half a dozen towns in Connecticut that actually do this right now. But I think people have figured out that they can try this. So it's up
And
to you.
so what, is there any magic to 5 years?
No, one town's actually got 10. So
A long time, actually.
it's really, if people are going to play games and say, well, then, you know what, I'm this $2 million piece of land, it's actually, I'm going to subdivide it, but it's going to my first cousin, so leave me alone. And now what do you do?
Right.
Right?
So why is this even in here? I guess is my question, since I'm just seeing it for the first
It's
time.
an issue which I've become aware of around the state, that people are trying to avoid the open space set aside requirement by calling for the family exemption. And you have to sort of accept it at face value and move on, or you need to have a look back provision in your regulations.
And Phil, Glenn, towns have experienced this. They've seen it happen.
Yes, I was involved in one.
And do we have the capacity to do the look back?
Exactly.
Oh, yeah.
You put on the land records, you file,
And we know that
Language
we
on
can
the-
go back and check that Jim Bob is second or first cousin to Joe Jane or something?
How about
No,
this?
but it's,
What if, I know a situation where a man's estate was to be divided amongst his children and his second wife, and he adopted their adult son, who was 35, then cutting him in as a child. So I mean, like, is there a slippery slope we get on?
well, so the point is that this creates a lien. So if they try to sell, there's a lien against the property and they.
So you don't have to check that necessarily.
Correct. So there's
you-
not like a regulation. It's
You can get the fee. It's just there's a 5-year look back on the fee.
I see.
correct.
So it's-
If they wait 5 years, then good on them, I guess. But
Right.
Is this required to be in there? Is it a required based on a statute or?
no,
There-
I think
the exemption is
the
required.
family
That's what
exemption.
I'm
That-
saying.
Yes.
Yeah, but
look
Glenn said
back.
there are only like 10 towns. Glenn,
a
and
lot, no, I think there's 5 or 6 towns that I'm aware of, but one town has a 10-year look back. So that's where the 10 number.
and so is it fair, would it be fair to assume that they're towns of large landmass? Like Guilford's one of the largest towns in Connecticut.
Mhm.
Does that make sense?
Yeah, I didn't actually look at the towns that, in terms of their landmass, the issue was the posture of an applicant to try to evade a open space set aside. I mean, most subdividers and most people who subdivide their property are not enamored with the concept of an open space set aside at all. They feel it's a tax and you're taking their property and
Yeah.
it's my property. My family has farmed this for generations. Why are you taking this away from me? I get that. I understand.
Yeah, I
But-
do.
You know, there's a large open space set aside in many communities, which the new subdivision is poaching off of if you don't have an open space set aside. So the
Hmm.
question is, how do we build a successful community? And having open space as we go is not inappropriate, I feel. But the question is this attempt to circumvent through a transparent measure or a sham measure or something is it's just something to be aware of. So I've automatically flagged this for us to talk about because I think it's controversial.
Yep. I
So
agree.
Good.
Thank you.
Thank you. I wouldn't have thought of it.
yeah, no, Phil, I'm gonna try to bring my experiences from other places to help at least let you know what other people are
We
doing.
don't need to go down that rocky road all alone, okay?
Yeah, there you go.
I got a question for Glenn.
Yes,
Are other communities that you're aware of wrestle with this open space issue like we do?
well, I haven't been at all your meetings, so it's hard, when you use the word Russell, I don't always know exactly what you're meaning, but some communities are very resolute in terms of the open space, and the issue is we're taking open space. Some communities require 20% open space set aside. And so they are resolute and make sure they get their 20% of as part of every subdivision. Other communities are 15, 10, 5. Some say, don't say shall, they say may. Every community is just a little bit different in terms of how they approach this. It's part of your DNA as a community in terms of how you want to approach it. But I think the regulation set up this way, I think puts the commission in the driver's seat to kind of make these decisions. Every subdivision shall make provision for open space. It can either be land or it can be a fee if we want to accept the fee or we want to require the fee. And now you've either got the land that you think is useful and valuable for the open space network, or you've got money you can put in an open space fund and then acquire the open space you really want in places where you really want it, et cetera. So I think it gives you the best sort of tools.
I also
So-
think it adds clarity to the developer. Like, you
Yeah.
have it defined, like, this is gonna happen. It's not may, it's gonna happen, and it's either gonna be the land or it's gonna be the fee.
Now, I think that gives developers, much clearer guidance about feasibility. No developer is going to, buy land and pay architects and so on if they don't know they're going to make a profit. So more clarity is better for them and better for us.
I don't think there's much else in section 3. There are provisions about energy efficiency and sustainability, erosion sediment control, and then flood hazard areas, which are fairly standard and mirror much of what's in your current regulations.
Which section
Section
is it?
4
that
is the infrastructure section. Big
I'm
yellow
so-
note here on page 25 that says, listen, we're working on the road ordinance. One of the things we have to figure out, for example, is there's usually a table of the road standards, that the paved width is this, the right of way is that,
Yep.
the maximum grade, the minimum sight lines, all these types of things. And they need to be somewhere. And they could
Janice
be,
is working on that.
yep. So the question
put
in a
'em in.
sense is, the road ordinance can deal with existing roads and the subdivision regs can deal with new, because we're not about to go back and change the grade of an existing road to comply with the subdivision reg. So what do we do? And so Janice is working on this, and what we're kind of envisioning right now is that there may be a table that comes into this regulations that has some of these road specifications in it. But most of this is sort of cleaned up, if you will, to reflect typical road design issues. When we get to page 28,
question?
yep,
Go ahead.
You kind of flew past the section 3.5 energy efficiency and sustainability, and I had to kind of go back and read it. What is the term you're using for passive solar energy? What does that actually say?
it's actually in the statutes. So the statutes were revised back in the 1970s to do this after the, Arab oil embargo in the 70s or whatever. The statutes were changed, and these are actually the terms and wording that's in the statute. So it's probably 40 or 50 years old, but it basically refers to passive solar technique, site design. So for example, in laying out a subdivision, if the subdivision road is east-west, then the houses have east-west orientations or north-south orientations, excuse me, on their wall. And so the solar works great. If the road is north-south, then you got sort of off on the short side of the house facing solar, and that doesn't work so well. So the statutes were designed back in the 70s to say that you can or should be considering solar techniques, and that could be.
So the statutes refer to passive solar energy, or do they just refer to solar techniques? Or because nobody really does this anymore in design, which is what I've been doing, but not this, but passive house. So there's a whole, we have to be very clear that it's not passive solar, because it really never took off because it never really worked. So is there a way to put in something different here that encourages people to use passive house techniques?
I guess that's a good point. It's not all related to solar necessarily. There's plenty of passive techniques that are passive energy techniques that aren't related to solar.
I think the problem we end up with here is the statute is worded in a specific way that many towns actually try to ignore this because of the impracticality as you have described. But the statute was set up to say that when you're laying out the lot lines and other things in a subdivision, if you need a solar easement over the property next to you, then lay it out now, because trying to get it later is going to be impossible. So it was meant to think about solar orientation in the design of a subdivision, or the right to clear trees on somebody else's property. And that's really not what's happened. So the statutes are quite specific in their language, and they're probably out of date. I will go back and take a fresh look at them. I'm pretty sure this is a cut and paste from the statutory language. So if it's.
Could I get a copy of that statute?
Yep, it's 825. Yeah, I'll send it to Aaron in the morning.
So
And then it says maximize solar heat gain and minimize solar heat loss. That really doesn't have anything to do with trees or land or anything. That has to do with the structure. So what does that actually imply?
I'll send you the statute. You can read it. So Bill, I look forward to whatever you're able to come up with in terms of ways that we can operate within what the statute says. Because or if in fact, we can get back to the legislature and tell them just get rid of this thing. But let me send it to you.
Make it better.
Well, I think, Bill, you've hit a nail on the head in a sense. The subdivision regulations really have nothing to do with the design of the houses. The subdivision regulations have to do with the layout and design of the lots and the other infrastructure. You can't regulate the type of house or any of the issues related to the house itself through subdivision, I don't believe.
But if it is incorporated into the statute, then we can because it's statutory. Is that correct?
Well, but I don't think you could override the state building code, right? You
The
can't.
building code though. So I mean, I think, let me do some research on this because I'm going to get the statute back out. There is a document, a report that was prepared back in the, I'd say, early 80s by the Naugatuck Valley COG that showed ways that subdivisions could be laid out to deal with these issues. And it may no longer be applicable. So we'll figure out what to do there. I do want the commission to know that with George and Aaron's assistance in the zoning regulations, we've created a whole section on energy and resiliency, which we think is much more cutting edge in terms of the issues that are going on today that we need to be aware of. And so that's an opportunity we've taken and rolled with, and we think you and others will be excited to see it. This is a little bit of a vestige or relic from old statutory changes, which may not apply, but we're still mandated under the statute to include it. So let me get the language through Aaron to you. And then I flagged this one to take a look at this as well.
But with like PV, with with photovoltaic, then orientation does matter. I mean, that is something that is important. So I don't know if that is also incorporated into the statute. I'd be glad to look at it.
Just a heads up that we have our regular planning and zoning
Right,
meeting
right.
in 6.5
7
minutes.
minutes.
So I just
We have
wanted to give you a
8
heads up.
minutes, I think.
Then my suggestion, Phil, would be that section 4 is a big enough section that I would suggest if the commission has a meeting in 7 minutes or 6 minutes, that I would suggest we might stop here.
Okay.
And pick up from here. So the remaining sections here, section 4 is the big section in terms of actual physical improvements as part of the subdivision, roads, stormwater drainage, fire protection, which is probably something we'll spend quite a bit of time talking about,
Yeah.
utilities, traffic signs, et cetera. And then we're into the process related stuff. So I think I am happy to coordinate with George and Aaron. We have a sense of when the next meeting or work session might be. And then
About
Yeah.
the 17th of March?
We're choosing, I thought our second meeting of the month would be our,
Yeah, that would be
look
March
at that.
7th.
Yeah, I already have it on my calendar. So the 17th of March works for me. I will do some research in the meantime and share it with you in the next couple of days. And then I'll see you on March 17th.
Terrific.
we'll continue
Thank
to
you.
do the 6 o'clock for this one.
That'd be
I
great.
think that,
That's
Thank
bye,
you.
everybody.
This was really great. Thank you so much.
Yeah,
you.
excellent.
Really
Thank you, Glenn.
Super
Well,
duper.
I guess I'm going to sign off and you guys can keep going. So thank you very much and I'll see you in a month.
Thanks.
All right.
Thanks.
Thanks a lot, Glenn.
Thank you,
See ya.
Glenn. Just for the record, it is Aaron's anniversary tonight, so we're going to be expeditious with respect to
Oh.
moving through our agenda. which
That what happened.
No public.
Yay.
Happy anniversary.
Anniversary. What kind of anniversary are you talking about here?
What's
Oh, a
that?
wedding
I assume
anniversary.
It's a wedding.
Oh, wedding anniversary.
Wedding-
Yeah.
Oh, well, congratulations.
The 5th
Thanks.
is always a special one.
The what?
The 5th.
The 5th. Yes. That's how you get 4 kids in 5 years. God help me.
What, no cable? All right, let's see.
14.
We got, can we,
I have one guest, an applicant actually,
we do?
joining the meeting here. Although it's not on for discussion. It's just a receipt and scheduling of the public hearing. So this is pretty fast.
Let's, I'm
Did
gonna,
we adjourn the other meeting?
yes, would someone like to make a motion to adjourn?
So moved.
Someone like to second that?
Second.
By a showing of hands, all in favor
What was I in favor of?
adjourning the meeting?
The
Okay.
special meeting.
Thank you.
May be noted that Sean abstains.
John abstained from the adjournment, that's fine.
Jamie too, I
As
guess.
he
huh?
All right, we'll start him up, we'll start this one up 2 minutes early, because or at least a minute early. We'll give it a minute and then we'll fire it up, okay?
Sounds good. We have
It
3
would-
receipts with public hearing schedules, and if
Is
You're
it possible
interested in
for
it.
Glenn to share his screen or so that I can, because I was getting lost at various times as to where he was in the, because he
For
could
the-
then point to
Oh,
things
don't
and
you have a
say,
copy?
oh,
Have a
for the
copy?
regulations, you mean?
yeah,
Yep, we can do that.
So like,
Oh,
like,
We
didn't,
can share the regs.
go
Yeah.
through, as he's going through, he can point it out. Is that right?
yeah, then he could use his mouse and go, and we're here we are, and
This is new,
Well,
or,
I mean, if you need a printed copy, let me know. I'm happy to.
no, I was following it on
That as
my
well.
screen, but he was jumping around and I wasn't keeping track, and
Oh.
I'd get distracted and I didn't know where he was. And so,
all right, Aaron, I think we're ready to go.
Okay,
Okay.
call it order.
Will the regular meeting of the Planning and Zoning Commission for Wednesday, February 17th, please come to order? This evening's meeting will be in a virtual planning and zoning meeting via the Zoom platform. I'm not going to go through our procedures because we don't have any public hearings. Seated this evening are the following members: Scott Edmond, Richard Wallace, Sean Cosgrove, Jamie Stein, Bill Freeman, Alan Brown, Frank DeAndrea, and I am Phil Johnson. Staff present this evening are George Kroll, our town planner, Aaron Mannix, our zoning enforcement officer, Lisa Piombino, our planning and zoning administrative assistant. I do not believe there is a legal notice for this meeting, is there?
Correct.
So
There
we
is
will
not.
move straight to our agenda, which I, of course, just lost in front of me.
I can share it if you're
Yeah.
interested. We have a lengthy list of pending applications.
Right, so Garrett Sullivan's extension is granted to 3-3. We will not be hearing that. 33 Pine Place LLC. Let's see. What are we hoping to do with that one?
That's a public hearing. Yep. 33 Vineyard Place is scheduled for public hearing at next meeting.
Okay. We
Same
also
with
have for the
52
next
Vineyard.
meeting, I think we can combine the two of these in a single motion. Peter Jacqueline, 52
Oh,
Vineyard.
these have already been set. These are
Oh.
just placeholders, so you're
Okay.
aware that
All right.
these
Dina
are pending
Nafta,
applications.
Has Dina
The
Nafta
only-
been sent?
Yep, the only update is that this 45 Clear Lake Road has been withdrawn. So you won't see this again.
Really?
She'll be applying for a variance.
Okay. And do we need to table, Amy Goldfarth's already been tabled?
Yes, these have all been tabled. They're awaiting their public hearings. The only new applications we have for receipt tonight
Nancy-
are 3 public hearings here to
Great.
set.
So Nancy M. Bishop, 64 Trolley Road, map 8, lot 63, zone R2, coastal site plan for removal of existing deck to be replaced by shed. Receive and set public hearing for 3/17. Also on 3/17, Gerald P. York, 75 Clear Lake Road, map 95, lot 19, zone R5, special permit per section 27338B to convert detached garage into art studio. Receive and set public hearing date for 3/17. Would someone like to make that motion?
so moved.
Thank you.
Second,
I will do a quick roll call vote. Scott Edmond,
Yes,
Bill Freeman,
yes,
Frank DeAndrea,
Yes.
Alan Brown, Alan. Give me a thumbs up, Alan. You good? All right, Alan's good. Who have I, Sean Cosgrove,
Yes.
Richard Wallace,
yes,
Jamie Stein?
Yes,
Very good. I will also vote yes, so that we will receive and hear those on the 17th. Next one is set for 3-3. William Gozi. I believe I have the pronunciation of that correct now. I always thought it was Ghazi, but it's Gozi. 595 Westlake Ave, map 89, lot 4-14, zone R7, special permit per section 273-19 for accessory apartment and new single-family dwelling. Receive and set public hearing date for 3/3/21.
so moved.
second,
second,
Thank you. Quick roll call vote. Alan Brown, you good? Thumb up? Up. There you go. Thanks. Alan's good. Frank,
Yes.
Bill,
yes,
Jamie,
Yes.
Sean,
Aye.
Richard,
Yes.
Scott,
Yes.
and I shall also vote yes. Let's see, any other correspondence, other or ZEO report?
No.
Thank you. Has anyone had a chance to review the minutes from the last meeting?
Yes.
I reviewed them and they appear to be substantially correct to me. Would someone like to make a motion to approve them?
So moved.
Thank you.
Second.
Very good. Scott Edmund,
Yes.
Richard Wallace,
Yes.
Ron Cosgrove,
Yes.
Jamie Stein,
Yes.
Joe Freeman,
Yes.
Alan Brown. There we go. I like the thumbs up, Alan. You're the best. And Frank DeAndrea.
Aye.
Aye. Yeah, thank you, Frank.
It's the pirate's favorite word. Aye.
Aye.
With no further business before the commission and with it being Aaron's anniversary, would someone like to make a motion to adjourn?
So moved.
By a show
Second.
of hands, all in favor.
Good night.
Take care.
Everyone.
See you guys.
Good night.
you.
Thank you.
Thank you.
Bye-bye.
Bye.
Good night.